according to some of the teachers means different, right? When we teach, we don't do research. Like number one compartment teaching, second compartment research. Research has no connection with teaching, or teaching has no connection with research. So that is general perception that has been created by some of teachers or students also. So research and teaching, right, must have integrated understanding. We can't teach without good research, right? Without good teaching, you can't conduct good research in any case. So research is the basis of teaching. Research is the basis of any profession, right? So therefore, we have that discussion. The research is a scientific and systematic investigation. Summarization of data or information is not considered as research. Fine. So when it comes to conducting research, how to conduct research, that is, I think, the real challenge. If I ask you to conduct some research on this particular batch, right? Fine. Now, what the intake total student in this batch? 57. Okay, 57. Right? If I ask you to conduct some empirical research or doctoral research on the basis of 57 students, involving 57 students, right? So, how are we going to select topic? Number one, how are we going to conduct research? Suppose you want to conduct some research on backgrounds of students, right? Male and female student, right? Student from public universities, private universities, then income group, right? Below poverty line, above poverty line. So this is called descriptive research, that you describe the group. The group contains 57 students. There are 27 female, 20 or maybe 30 male students, right? They are belonging to particular category, BPL so many, APL so many, etc., etc. English medium, Hindi medium, or Telugu medium, etc., etc. So this is the way we conduct descriptive research. We describe the group in order to know about the group, right? But you must be in a position to really examine the parameters, right? So describing group, of course, you know the group, right? How many teachers are appointed? You come. How many teachers are appointed? The basic qualification of teacher, experience of the teacher. So this is the way you conduct descriptive research, right? The second research is explanatory research, right? Explanatory research regarding anybody, like smoking causes cancer, right? Means independent variable and dependent variable. Smoking causes cancer is well established. If you want to conduct some research on explanatory research, right? See, explanatory research requires some kind of explanation, some kind of connection, causal connection between two or more variables. Like if you want to conduct some research on this particular batch regarding enriching understanding of research methodology because of this lecture, right? That your understanding with respect to review literature or research question, or maybe that systematic approach to research, right? Any research has improved. How are we going to conduct that research? How are we going to conduct that research? That this training program or faculty development program or orientation program or special lectures program has enriched your understanding. What will be the nature of that research? Program and impact, right? Program and impact, but there are moderating variables. See, attending a program does not guarantee you to learn something. You have to have interest, you have to have basic understanding, right? If you are here only for attendance, you are not so serious about learning, so you won't be in a position to really provide valuable inputs, right? If you are here, right, you are physically available, not mentally available, you are busy with your laptop, busy with your mobile phone, right? So there can't be any direct connection between the lecture and the quality of learning, right? So it is very difficult in case of that causal connection or that the research, that is explanatory research. So you have to take care of variables, right? See, I have done some empirical research on legal aid councils, right? Legal aid councils, like competency of legal aid councils and commitment of legal aid councils and quality of services provided by them, right? Competency means parameters. Whenever you talk about competency, like you are asked to evaluate some teacher's competency, we have feedback system, right? Students are required to provide feedbacks of competence of a teacher. So in that case, what is required? Subject matter competency, punctuality, whether teacher is available on time or not, whether teacher delivering contents, etc., etc. But you don't really expect students to evaluate competency, because teacher, see, there is, right, students don't have that basic understanding. A teacher may have better understanding. See, when I teach LLB student, I have to go down to that level, UG level, right? I teach LLM student, my approach would be different. When I teach research, PhD scholars, my approach would be different, right? So I have to go down to that level which is required for UG or PG course, right? So if that is the case, you won't be in a position to really evaluate the person. But coming back to that, the explanatory research in case of legal aid parameters. Yes, sir. That the same slide. We'll discuss it, right?
Yes,
so in case of in case of explanatory research requires justification as to why smoking causes cancer, as to why people do not opt for legal aid services, as to why people opt for NLS Bangalore as compared to NLU Delhi, right? As to why people prefer NLS Bangalore as compared to DSNLU or NLU Assam or any other institution. So you have to explain the parameters, ranking, etc., etc., quality services, quality teachers, etc., etc. Fine. If you go by the perception that is created by NIRF ranking or world ranking, you are likely to be misled, right? Because these are marketing tools. So that explanatory research requires valuable inputs, competency of teacher, competency of legal aid council, right? And the competence of legal aid council can be evaluated by a judge, right? A beneficiary cannot evaluate the person. So whenever you examine that explanatory research, you are required to provide proper justification. Because I have conducted 3 empirical researches on legal aid councils that approach, I have first-hand information regarding functioning of legal aid services in India. Right? So number 3 is exploratory research. You know what is exploratory research? See, in all the cases, whether descriptive or explanatory, the nature of research will dictate nature of research question, nature of research hypothesis, nature of objectives, and nature of research design. The moment you conduct empirical research, your nature of research design would be different, right? Nature of research design would be dealing with specific requirements of non-doctoral research, empirical research. You are required to have some specific universe, sample size, stratified sampling, right? The territorial area. So that would be a specific research design in respect of empirical research, right? So that nature of research is very pertinent with respect to other activities. So it is very systematic approach. You start from review of literature, then you move to say research problem, including research question, hypothesis. Now see, there is a doubt. The doubt has been created by some scholars that the moment you have research questions, you don't require hypothesis. Is it so? Do you buy that argument? In case you have research questions, hypothesis is not required. In case you have hypothesis, research questions are not required. Is it so? Do you buy that argument? Now we have that perception, especially in case of legal education, legal research. You must have hypothesis. Maybe descriptive hypothesis, explanatory hypothesis, or exploratory hypothesis. See, in case of exploratory research is related to that area which is unexplored, that has not been examined by anybody, or that area has not been explored, like blockchain, use of artificial intelligence in case of judgment delivering, right? And then in case of plagiarism, use of AI tools and techniques in case of plagiarism, detecting plagiarism, taking care of corruption in case of academic publication, etc., etc. right? So this is, I think, very important when you do research. You have to really identify nature of research. That is important. Then you follow other patterns. And conducting research means you must be very sure about subject matter, right? If you want to do some research on artificial intelligence, we can't expect you to know all technicalities, right? Artificial intelligence deals with, number one, law to regulate. Number two, technical aspect, like you may not be aware of the technology dealing with the algorithm, right? Dealing with that specific requirements, how that is designed. It may be related to patent. You may not be well versed with the patent requirement because it deals with technical specifications, right? But as a legal practitioner, legal professional, you must know law. That is only the requirement. But if you know both the parameters, I think you will be the best person to conduct any research. So therefore, interdisciplinary research becomes very important. You can't examine AI law, AI tools and techniques without having technical specifications. Similarly, cryptocurrency, Bitcoin, etc. These are the specific subjects where you require some technical inputs. Otherwise, you will be dealing with this section, that judgment, that's it. That is only the process requirements, right? And all these process requirements are available in the public domain. So you must be very thorough about that. Yesterday I talked about insider's perspective. So insider's perspective is directly related to that specification, right? If I teach labor law, I must know the functioning of labor tribunal. If I teach IPR, I must know how to register IPR, how to file application. And when I teach corporate law, I must know how to register a company, how to create a company. What are the online services which are available? How to pass a resolution, right? How to upload that resolution on that web page. MCA, that Ministry of Corporate Affairs, has introduced specific policy for submission of resolution, application, etc. If somebody teaches CPC, that person must know functioning of civil court in case of IPC or CRPC is the case may be. So friends, practical inputs are very important. See, I tell you, there are several reported instances. See, one lady was working on prostitutes. She wanted to know about prostitution, right? So she became part of that prostitution in order to have that first-hand information. She recorded all the findings, right? So, patient is the best doctor. A patient would be in a better position to tell you the suffering, the implications. If you formulate some policy by sitting in air-conditioned room and policy related to workers, can you do that justice? So that is a real problem of our research. We confine our research to only specific parameters like, you are going to conduct some research for the purpose of presentation. Have you received topics? Not yet? So dissertation is very important component of your course. Right? Dissertation is very different from your LLB research project. Right? Let us see how you are going to do that. That is the most important component, a kind of thesis only. Right? So while writing the thesis, try to have a specific topic. Pointed topic, not generalized topic. Because generalization is never considered the research. Labor law. Critical examination of labor law in India. What is this topic? Critical examination of criminal law in right, or NDPS or UAPA. Prevention of Corruption Act. A critical analysis of money laundering act in India. Is it research? Or corruption, Prevention of Corruption Act. Now, if you do some research on deemed sanction, a critical analysis of deemed sanction on efficacy of accountability of corruption, that there is a possibility to go research. Because deemed sanction is a problem in case of prosecution of public servants. We also created Lokayukta, right? So I think this is a very general submission on how to conduct research, what are the prerequisites of conducting research. Now, yes sir, that same video. Let us see this video and I want your participation, friends. Your valuable inputs in order to respond to that the specific video, right? Number one, nature of research. Number two, research design followed by the researcher. Number three important parameters regarding that. Right? This is the top one. Right click and then open that. ऊपर वाला YouTube. Is it working? Copy paste, just copy it and paste it on the internet. You have internet connection, right? Copy it and paste it on Google. You will have that link. We can play that YouTube video. Right? Mentions. We have conducted some empirical research on conflict of interest, right? And you must have seen some research assignments like article is written by a student, teacher becomes the first author. Article is written by a teacher, wife becomes second author, right? And some issues regarding exploitation of research scholars. I think a lot of issues. So we have to really take care of ethical dimensions of conducting research, and we don't have that time to really discuss ethical dimensions. Very important parameters of conducting research. Ethical dimensions. We are very fond of creating data, right? Creating false data, forging data. So how to really deal with that? The forging data, modification of data, dilution of data, and then coming out with some kind of findings which are not directly related to your research question or hypothesis. So this is not a research is no matter of convenience, that you do it for your convenience. You modify the findings according to your convenience, and findings are not supported by any data, any document which is available for the document. But we do it because it's a matter of CGPA, matter of grade or rank, etc., etc. Right? So success at any cost means are irrelevant. That is the mantra of 21st century. So we don't believe in that, because hard work is always recognized in the long term. May not be recognized in the short term, but that is always recognized in the long term. Fine. So in case of the particular, I think video working, let us see that video. So have you confined your discussion or study to any particular book? Which book has been referred by you? Any particular book? There are good books on research methodology, published by Sage publication, Pioneers, right? Several books. I am not referring to some A or B book published by Indian publishers. There is almost repetition of the literature. Not referring to Kothari or any other book. I am talking about Sage publication. Several books talking about scientific research methods in case of social science, qualitative and quantitative research methods in case of social science. So read some good books. Yeah.
Sir, how the research methodology in social science is relevant in the realm of research in the law, the field of laws?
Research methodology.
Research methodology that we adopt in the field of social science.
How
it is relevant in the field of law where we are
right, good question. I think that is the real problem. Let us see this video first. Sound please. Now see, sound, sir, unmute it. Ghana river pollution, illegal gold mining,
countryside.
Start.
Yeah. Our children often fall sick.
This is what Africa's largest gold producer looks like from above.
Start from the
Gold
beginning, sir.
production is boomed in Ghana.
Right.
This is what Africa's largest gold producer looks like from above. As gold production has boomed in Ghana,
Let me see.
illegal mines have sprung
W
up.
attention and research methodology in case of social science. Yes, stop it, sir. Fine. So have you seen the video? If I ask you to summarize basic issues raised by the video and the nature of research conducted by the reporter, right? And then the implications. Let me see somebody. What is the nature of research conducted by the researcher? Descriptive, explanatory or exploratory? It's a combination of explanatory and exploratory research. In this particular case, the researcher has examined impact of illegal gold mining on health, water pollution, enforcement and other issues. Fine. So this research has adopted multidisciplinary approach, not confined to only law. Right? Law means that only pollution component. Right? There shall not be any water pollution or this and that. Right? There shall not be illegal mining, etc., etc. That is a very small component of the research assignment or that specific research. It deals with number one, health law. It deals with water law, water pollution. It deals with several implications, right? So this research deals with multidisciplinary approach. Fine. Where researcher has examined impact of illegal mining on health. Fine. Several patients have been examined, and the researcher has recorded feedbacks from experts like doctor, right? Enforcement agencies. That person has also conducted interview of respondents or the victims who have suffered because of that illegal mining or after consumption of contaminated water. Right? He has also discussed this issue with enforcement agency. It is happening because of various parameters. Don't you think this research deals with economical dimensions? Right? Yeah, of course, it deals with economical dimensions. Illegal mining is happening because of unemployment. Illegal mining deals with economical resources. Right? So this is a perfect example of multifarious approach or multidisciplinary approach in case of conducting research. So this is always expected that you conduct that research where you have number one, legal approach, examine legal dimensions, social approach, economical dimensions, political dimensions, maybe historical dimensions, right? So Africa is not poor because of its existence. Africa is poor because of exploitation, because of corruption. Africa is very rich continent, right? They have huge resources, minerals, but they are being exploited by Western countries, etc., because of corruption. So this is I think the good example of lack of enforcement because of corruption. That researchers has also discussed that the component of corruption. Illegal mining is happening because of corruption. Illegal mining is happening because of lack of enforcement. It is happening because of compulsion and employment, right? So author has examined the causes of that illegal mining. So it deals with explanatory, and the substantive part is explanatory research. It has also examined exploratory component, the remedy. What is the remedy available? How to really enforce the law. You can't enforce law unless you take care of remedial measures. Fine, we have enacted so many legislations, Dowry Prohibition Act. Have we stopped dowry? We have enacted Prevention of Corruption Act, RTI, Lokpal, Lokayukta, money laundering, several legislations. Have we stopped the corruption? Right? So this is addressing your issue, right? Yeah, good friend. Coming back to that issue. So do you think law is an independent discipline? Right? And this is again directly related to the research methodology which is required to be followed in case of legal research. So you have to understand, do you think law is independent discipline? Do you think law is independent of social science? Can you examine law from that perspective? Only knowing section, judgment, that's it. That is sufficient to conduct any research, quality research. Right? We call it paper research. Fine. Paper research does not contribute to existing pool of knowledge. Fine. Now let us see. Do we require special research methodology for legal research? There are some arguments. I have seen some professors claiming that number one, law is different from social science. Therefore, we require a special research methodology for law. Is it so? Do you think law is independent of social science? That's the question. Yes.
Sir, the law itself is not independent. However, the methodologies we adapt to while researching in both the field are, in my opinion, different. We have to adopt different strategies while researching.
Okay, let me see, just illustrate your point. One topic.
Yes.
You say any topic where you can conduct pure legal research without involvement of social science. Any topic.
We cannot adopt pure legal research. However, we can adopt pure social science research.
Okay. Let us illustrate that point because you have to have clarity.
Take an example when
Ah.
while we are conducting a legal research, we have
Select a topic. Select one topic.
uh,
Apply legal research methodology.
take an institute like DPDP Act,
Uh-huh.
Data Protection Act.
Right.
We have to consider all the factors that are on how that law is going to have an effect on the society as a whole.
Okay.
However, when we are conducting a research in the social sciences, social realm of social science, the legal point is not involved in that research. But when that legal point comes in that research, that is the question.
My dear friends, see, let it be very clear. It is very scientific. It has been accepted by several scholars, right? And we are talking about research methodology in 21st century, right? So number one, see, law is integral part of social science. Law is required to regulate society. Law is required to regulate economical dimensions, like in case of minimum wages, right? You must have studied minimum wages. You have Minimum Wages Act. So Minimum Wages Act has legal dimensions. Employer shall pay this and that, right? So minimum wages deals with legal dimensions. But don't you think it deals with economical dimensions also? Right? Minimum wages means guaranteed minimum wages. Guaranteed minimum wages means that minimum wage must be in a position to provide comfort, education, necessity, food, shelter, clothing, etc., etc. Uplifting the state of the person, social dimensions, right? Number two, several dimensions, not only economical dimensions, it has constitutional dimensions also, because minimum wages has been recognized as a part of fundamental right under Article 23 of the Constitution. Fine. So can we examine the efficacy of Minimum Wages Act from the perspective of some section, some provision, some judgment? Therefore, number one, see, we require law to regulate, to facilitate, to control society. That is the starting point, and you can relate it to any jurisprudence of any law. Corruption law, RTI, or maybe CRPC, CPC, any law. Right? Each law has its own history, and this is my observation that all the laws have emerged because of dilution in ethical values. Right? Any law, talk about any law. We have implemented all the laws in order to control human being. So, laws, primary or secondary laws are the tool of controls, facilitation. Right? So, if society behaves in orderly manner, you don't require any law. We require law to regulate attendance because students do not attend class regularly. We require record attendance because students are right, they support their friends through proxy attendance. We require facial recognition. Why have we implemented this the plagiarism, right? The plagiarism policy? Because people used to do research of that nature, borrowing something without quoting anybody. So we require plagiarism software because people have misused, people have manufactured, created false research. Right? So you require some tool in the form of anti-plagiarism software. Now, sexual harassment law. Sexual harassment law has been implemented on the basis of past history. How the women were exploited. The Bhavani Devi judgment of 1997. Right? Thereafter, the judgment of that statute of 2030. Fine. So social problem, see, sexual harassment does not deal with legal problem alone, it has social problem. It deals with status of women in society. Like, it deals with economical status of women. You know, no, right? If some women is employed, she has resources, so there won't be any possibility of some kind of domestic violence related issues, ill treatment or otherwise, right? So if you examine all these statutes from different perspective, applying multidisciplinary approach, then in that case, do we require some kind of different, I think, research design which is different from social science? See, research is scientific. Fine. Now, if you feel that the statute is a primary data, that is the general perception that has been created by several authors, several professors, that statute is a primary data, isn't it? Or judgment is a primary data, report is a secondary data. It means we don't know about fundamentals regulating the classification of data. That is so simple to understand. What is primary data? The classification between primary data and secondary data has been explained by several researchers. So much of literature is available. This is primary data. And data is created, right? How data is created? You have interview method, so many writing tools and techniques. Primary data is first-hand data. The moment I collect some data from respondents, right, I make some observations, analyze the data. So that is the data which is part of primary data. Secondary data means you use data. Let it be your judgment or their act or any report, any article, anything. So if you apply these fundamentals, right, very easy to draw some conclusion that statute is a secondary data. But if I make some statement that statute is a primary data, how come you are going to justify? I appreciated our argument that statute is a primary data. What is the logic? It
was created by them.
Yeah.
It was created first time. So that is
They created by the legislator. Now you are using that. You are using that statute. You are quoting the judgment. You are not the creator, isn't it? So if that is the case, what is the logic? If you go by that, see, if some statement is made by some professor of high profile, high repute, and let me illustrate it with the help of one particular example. See, there was a lecture delivered by a very eminent professor, and he was also there. I am talking about LRS Bangalore 2017 or 18. Fine. There was a discussion on empowering teachers. It was related to that whether a student-centric approach or a teacher-centric approach is important for teaching. Then I asked him whether student-centric approach is important or teacher-centric approach is important or profession-centric approach is important. Right? So you know what is important as of date. It is the profession-centric approach. You must know whatever is required by the profession. So our duty is to empower you to develop those skills which are required by the profession in the market. If you are not in a position to draft some application which is required to be submitted to a civil court or maybe tribunal, what the purpose is LLB or LLM degree? Number one. Right? So this is the way how you generate new knowledge. If you go by somebody's statement that yeah, this student-centric approach is very important, that has become history. Right? So this is the way how you learn, innovate. So research is important. If you claim that you require special research methodology for legal research, I am very sorry friends. You know, logic, again I am relating to that component. You know logic, inductive logic and deductive logic. Do you know third logic? Any idea about third logic? Have you heard of abductive logic? Right? Abductive logic may be applied in case of exploratory research. Like all trees are green, the table is green, so therefore this table is a tree. That is abductive logic, very irrelevant. But there is every possibility of exploring that hypothesis to really find out, define some hypothesis. You know what is inductive logic, deductive logic. See, of course, logic is very important in case of conducting research, right? Inductive and deductive logic, these two very important for review of literature, very important for formulating hypothesis, right? See, these principles are very important. So you should go by that inductive logic and deductive logic in conducting, analyzing, shortlisting, applying the theory. Right? Now, if you claim that you require special research methodology, let me see some justification. I appreciate that. I love that interaction and discussion. When you make that argument that of course we have to have a special research methodology which is exclusively meant for law subject. Can we have some more arguments? Let me see. Now, if you make that argument, I appreciate. I am not ridiculing that. Right? I am not criticizing that. Right? Let me see. If you claim that we require special research methodology for law, because law is very special, law is very different from social science, law is very different from economical dimensions, like competition law, right, insolvency law. These laws are based on economical dimensions. Fine? Yeah, let me see some participation. Right? Why do you require special research methodology for law? The debate is going on. Yeah.
Sir, suppose we are conducting an empirical research, the source which we are referring to, if in case of legal empirical research, the source and the data which we are procuring is from the authority itself. Let's say it's the state. But while we are conducting a social research in the social science realm, the empirical data that we are collecting is from the general public at large.
What is the problem?
So there is that difference.
No, my dear friends. Now the data is collected from government agency, right? You conduct interview of public information officer or maybe some VC or some director, right? With respect to specific point, right? Maybe related to sexual harassment, maybe related to ragging, maybe related to any particular issue. If you want to conduct that ragging, right? Whether regulations formulated by UGC are meticulously respected by all public and private universities. So in that case, who will be the respondents? Number one, students, junior and senior students, UG and PG students. Fine. Number two, teachers. Number three, the committee who is assigned with the responsibility of ensuring anti-ragging regulations. Fine. Then add with this data. Then you have to really examine filed cases regarding ragging, because ragging is a crime. Right? You have to examine those cases which have been filed by somebody. If somebody has been victimized, then you have to record the feedback from victims also. Then thereafter you draw some conclusion on the basis of the data. Does it make any difference when you collect data from private individuals or you collect data from state agencies? Is it going to make any difference? See, I have collected some empirical data from advocates, from judges, right, from jailers, right, superintendents, under trials. See, data is a data for me without any identity. I am going to draw some conclusion on the basis of like 50% or 70% of the students were of the view that ragging regulations have been implemented satisfactorily. Right? They are satisfied with the anti-ragging regulation. So I am going to quote the data in a particular way. Whether data, yeah, of course, you can have that classification. UG students, PG students, teachers, etc., male student, female student. You can have that classification for the purpose of pattern analysis. Right? So you can have that cross tabulation in order to examine other parameters. But the logic you are going that see that data collected from government agencies would be different from private agencies, I think which convenient nahi hai. Right? Now see friends, see of course, see no one is perfect. If you feel that research methodology the legal research requires specific research methodology, then what is the specific nature that is required? Research design. Number two, research questions. Number three, hypothesis. What is so important about that? That is also important. So you have to research the research methodology. Then we can talk about the social science or law or non-law? See, according to my understanding, a limited understanding, law is very small component of social science. That's it. You can't examine law in isolation. Suppose you want to do some research on right to education. You have that act, right to education, Article 21, capital A. Fine. You want to just examine efficacy of right to education. So what will be your responsibility in case of right to education? What is expected from you? Let me see. You know right to education? Right. If you are assigned with the responsibility of examining right to education, efficacy of right to education in this particular district. What is this district called? Visakhapatnam. Fine. How are you going to conduct that? What would be the literature review component? Literature review. Because literature review is starting point. Efficacy of right to education in Visakhapatnam district. Before that, what is required to get examined by you? It's a very broad topic. Efficacy must be based on some indicators, right? You know, right to education Act provides for reservation. Reservation to BPL category students. You must have seen some high level schools, right? Where very difficult to have access to that the schools. Poor people can't have access because they charge so much, right? See the fee structure, they have competition fee, etc., etc. So because of that, we have reservation, some 5 seats, 2%, 1%. That is determined by the state policy. If I ask you to conduct some research on right to education, what will be your approach? This is regarding review of literature only. I am asking you to examine review of literature component. Yeah, anybody? Yes. What is the relevant literature regarding the policy laid down with the state of Andhra Pradesh? Right? You are required to examine the contours of the policy, availability of benefits. Right? Number 2, what are the benefits available? Then you are required to verify whether these benefits have been extended or not. So therefore, empirical research. Can you examine efficacy of that law by conducting some kind of doctoral research, or I call it library research? You sit in library, examine policy by other government, RTI, that RT Act, or some judgments delivered by Supreme Court or High Court or maybe District Court. Can you examine the efficacy on the basis of that literature? Certainly not. Because the nature of research requires some data to support that argument. Fine. Then suppose you want to conduct some research to evaluate J.S. Mann's competency. Competency regarding number 1 research methodology, number 2 labor law, right? It has a context. Competency has a context. The more you are going to evaluate a person on the basis of general, I think, perception, then there is no research. Context means understanding of J.S. Mann with respect to labor law, with respect to administrative law, with respect to research methodology, with respect to RTI, with respect to prevention of corruption act. That is the parameter. So can you evaluate the competency of J.S. Mann on the basis of perception of some individual? Right? What happened in case of death penalty? Right? The particular research was conducted and the data from death row prisoners was collected. Only death row prisoners. No judges were involved, no advocates were involved, no policy makers were involved. Right? Data was collected only from death row prisoners. Fine. So you must understand who is a victim. Do you think the person who has killed 50 people can be considered a victim? So your perception must be very clear. You are considering somebody who has killed 20 people as a victim. You don't talk about rights of those people who have been killed. So that is again a matter of perception. Right? So research requires an objective approach, not a biased approach. That you feel something is wrong, so therefore you feel that everything should be deleted, everything should be destroyed, everything should be changed according to my convenience, that nobody is going to appreciate that argument. So the logical argument based on relevant inputs, relevant facts, right, is always supported, always appreciated by researchers across the globe. Fine. So this is the way I think you can really conduct a good research. Yeah. See, in case of legal research methodology, right, you don't require any spatial research methodology according to my understanding, because law is again a very small component, 10% of social science. You can't examine the subject or topic in isolation. You have to examine that subject from various dimensions. So therefore, if we discuss the doctor example, right? Doctor treating the patients only on the basis of symptoms. Fever, headache, etc. etc. Okay, table it. Number 2 patient, right? The patient is treated on the basis of symptoms explained by the patient and some preliminary investigation, BP or temperature. Third person, right? There is a third doctor, he or she treats the patient on the basis of all parameters, thorough investigation. So which one will be appreciated? That someone is well aware of only section provision judgment, that will be appreciated. Somebody who has done some deep sea fishing, like the third doctor, right? Symptoms. Number 2, preliminary investigation. Number 3, thorough investigation. Who is likely to be appreciated? The third one. Because the third person would be in a better position to provide accurate, and I tell you in case of legal aid research, this will be the final component because you have, right, fine. See, I have conducted 3 medical researches, field studies on legal aid. First legal aid research was conducted in Delhi, 2014 and 16. Fine, 11 districts and Delhi High Court. To evaluate competency and commitment of legal aid councils as to why people opt for legal aid services. Whether they opt for legal aid services because of competency of legal aid councils or compulsion of resources. Right, now see 3 empirical researches. First research, according to first research, people opted for legal aid research because of lack of resources to engage private counsels. Meaning, it means people opted for legal aid counsels because of lack of resources. So they were forced to opt for legal aid counsel services. 90%. Second research was conducted in 2019, all India research, 18 states, 36 districts. And see what was the conclusion on same parameters. 82% respondents were of the view that they opted for legal aid services because of compulsion. They did not have resources to engage private counsels. And third, the recent one, 2023, on 100 trials, 10 states, 20 districts. Same 77% of 100 trials were of the same opinion. Right? Now, if you follow the pattern, 90%, 82%, 77%, it means substantial part of the beneficiaries opt for legal aid services under compulsion. This is a fact. And I opted for stratified sampling method. Like judges were involved, judges dealing with legal aid counsels were interviewed, legal aid beneficiaries were interviewed, legal aid counsels were interviewed, the member secretary of legal aid services committee were interviewed, women were also interviewed. Right? 5 stakeholders were interviewed in order to have accurate, authentic and representative sample. So there is an outcome. Right? So the legal aid deals with economical dimensions. People do not have resources, so therefore they opt for legal aid services. Right? So these are the issues. If I confine to only this section 12 of that Act, my understanding is very limited. Right? So therefore it is very, very pertinent, friends, that let us do that high quality research. And the moment you conduct high quality research, you are always appreciated, I tell you. Fine. So high quality research is the key. You are not required to market your product. I have seen people marketing product, displaying certificate on Facebook or LinkedIn or anywhere, participated in this seminar, that seminar, right? So this is not the way. The moment you conduct some high quality research, people will invite you, appreciate you, quote you. I have done some empirical research on legal aid. The paper was published in EPW. You know, EPW is very, very difficult to publish a paper. process is very technical, very rigid process, they go by the quality. Paper was published, it was quoted by several authors. I don't know how many authors have quoted that. On the basis of that, I got some invitation from Parliamentary Standing Committee to make a representation. The same paper has been quoted by Amnesty International. Right? So it is not that J.S. Mann can do that research. Everybody can do that research, that good quality research. But what is important? That passion is important. Don't feel that you are doing that research only for dissertation requirement. But do that research in order to learn, in order to unlearn. That is very important. If you are not sure, then try to unlearn, try to learn new concept. Otherwise, don't simply follow anybody. Don't simply follow J.S. Mann or B teacher or C teacher. You must have your perception, but you have to do that research. You must be very sure about one particular argument. And I tell you that as a concluder. See, there was, judicial review. I hope you know everything about judicial review. Fine. Judicial review means 226 on Article 32. See, at that time I was working on one paper, impact analysis of L. Chandra Kumar versus Union of India on functioning of administrative tribunals. You know that CAT, right? Administrative Tribunals Act 1985. I had examined the judgment, right? And I was working on one particular issue, judicial review. In case of 2 to 6, what happens? 2 to 6 is different from appeal. Judicial review is different from appeal. Judicial review is different from review. Judicial review is different from reference or revision as the case may be. Right? So I was very sure about judicial review. And what has happened in case of L. Chandra Kumar judgment? See, in case of Administrative Tribunals Act 1985, there is no provision of appeal. There is no appellate provision that scheme has been created. Fine. Now, according to L. Chandra Kumar judgment of 7 judges bench, and I am referring from para 93 to para 100 of the judgment. Appeal against a decision of CAT, a person shall approach a division bench of High Court. Against the decision of division bench of High Court, person shall approach Supreme Court. A person shall not approach Supreme Court directly. It means 136 becomes redundant. 136, that nature and discretion of Supreme Court to accept SLP. There is a direct route, right? So High Court under 226 cannot act as an appellate authority. Judicial review deals with decision-making process. It does not deal with the decision as such. Right? I had a discussion with a very senior professor. That time he had put up more than 25 years constitution. I asked him, sir, do you think High Court under 226 can entertain appeals? Oh yes, you don't know this? That was his response. Right? You don't know. Just read this book, that judgment, this judgment. He was very senior. That time I was assistant professor. I talk about 2008 and 9. He told me, you don't know all basic things. What do you teach? I kept mum. Because I was very sure about that judicial review process. I was very sure about 2 to 6. What is available, what is not available. Right? So this is understanding, level of understanding. If you don't understand what is judicial review, you make that comment as if other person is fooled. So don't create that impression that you know each and everything. Right? Judicial review is very different. Right? Supreme Court cannot modify the nature and scope of judicial review. 226 cannot be modified for the purpose of CAT, SAT or JAT. There is no appeal provision, so therefore there can't be any appeal before High Court. High Court under Article 226 cannot act as an appellate authority. And number 3, Supreme Court cannot dilute Indian Constitution. That Indian Constitution is supreme. The 3 organs are subordinate to the Constitution. So do you think that is, if you apply L. Chandra Kumar versus Union of India, 136 becomes redundant? You can't approach Supreme Court directly, isn't it? You have every person has to approach High Court first, then Supreme Court. This direct route is not available. So don't you think there is a violation of separation of powers doctrine? isn't it? So I have written that down. Published in that I think 2009 or 10 or 11. So I did research to examine judicial review. I did research to examine separation of powers. I did research to examine that Administrative Tribunals Act 1985, and I also examined some 25 judgments, where some of the judgments have ignored L. Chandra Kumar. Some of the judgments written by Supreme Court have accepted L. Chandra Kumar. Right. So this is the way research is expected to be conducted. Right. So I think you can also do that case analysis, case comment, but you have to really know the subject matter. And if you know your subject matter, if you know your profession, you are not required to know others. That is my understanding. So therefore, independent thinking. Therefore, quality research becomes important. Right? Because the profession is required, is recognized from his contribution, not from his designation, that he is a professor, or vice chancellor, or this and that. Right? So we all are students. Fine. And this is my final humble submission, friends, that a good human being can only become a good professional. Right? So therefore integrity becomes very important. Your integrity is always recognized. I always preach and practice that integrity is the key to become a good professional. Fine? Honesty, integrity. Try to learn and know new things. Fine? Okay, any question, any clarification? Fine, I know that. Yes, please.
Sir, you just mentioned that when you were researching about the competency of the legal aid council.
Okay.
Sir, how did you decide the factors, or you mentioned that there are some indicators when we are researching?
Yeah, see, when it comes to competency, right? Competency is based on specific indicators. Like in my case, we use number one, right? Number one, drafting skill. Number two, articulative skill. Number three, there's three skills. We use three skills, and then overall. And all these skills were evaluated by judges. Right? We evaluated the competency of legal aid counsels from the perspective of judges only, not from the perspective of beneficiary, because the beneficiary is not in a position to evaluate. And we also evaluated that skills from the perspective of member secretary. Member secretary is a judge, right? So we collected the data from these stakeholders. Of course, we have taken into consideration the feedback from beneficiary from the perspective of commitment, whether the advocate was available, whether the advocate was interacting, whether the advocate was providing relevant information regarding status of the case, right? Whether that advocate demanded money in addition to the honorarium paid by legal aid services. Several cases demanding money before starting the case, because legal aid counsel gets that honorarium after conclusion of the case. It does not get anything at the beginning. That is one of the limitations. Now, on the basis of my empirical research, field studies, NALSA regulation 2018 has been amended substantially. Number two, that new scheme 2020, where legal aid counsels are engaged on tenure basis, full-time basis. Right? So there are several recommendations which have been accepted, but of course nobody is going to recognize you. Fine? Because time and again we refer to foreign judgments, foreign authors, foreign scholars. You see Supreme Court? Ghar ki mulki kya hai, tar barabar. Right? That is the real problem. We don't recognize. Yeah, I'm done. Thank you very much, friends. Have a nice day.